Good afternoon, master builders. So we're going to continue on with the subrogation lecture. I had this almost done recording, but what I realized is I'm recording this on my phone until I can figure out how to set up the screen share software on my laptop. And maybe I need to turn my phone to the side so we can see those images a little bit clearer. I was watching the last video on YouTube on a computer this morning, and I noticed, obviously the up and down formatting is different than side to side. So I'm going to try to do this part by rotating the phone and see if that makes anything different. I also am going to zoom in to these documents so you guys can see better, because I noticed that was an issue too. So I'm going to go back and re-record. At least going to be 2 more parts to this. I'm hoping I can wrap it up in 2 parts, but there might be 3. But you guys want to know how to do this, and you want to understand the process. Subrogation gets rid of court cases, debts. I mean, it's all just debt and commerce. You know what I'm saying? So this is worth the time that it's going to take for you to watch this. I promise you. All right, so I had sent this to myself earlier. I know you guys can't see great right now. Give me a second. Okay. So I'm just going to go ahead and download these documents. Okay. So, I want to do the I said we do the nominee agreement first. Okay. So nominees, right? A nominee is essentially an assignment, and by operation of law under the Revenue Code. Okay. So a lot of this stuff happens by operation of law. There's not always a necessity. You think, oh, I need to file UCC-1 against my birth certificate. And first of all, listen. The trust that was created is irrevocable, okay? You can't revoke it, okay? Thinking that you can come out of this system, it just doesn't work like that. What you need to learn how to do is administer. You have to learn how to administer, okay? Because it doesn't matter what kind of paperwork you have. You got a fancy national ID, you got a 5-star passport or whatever. As soon as they get your name, they're going to charge that name, okay? They're not going to stop this stuff, okay? So, let go of that. So, I'm going to show you guys a few documents. This one's from DOJ. We're going to talk about what a nominee is. The nominee is a straw man. This is the word they use for it, right? So, this is part of what I'm talking about in learning how to speak legalese instead of using all this outdated sovereign language that's getting you labeled as a terrorist, okay? Straw man is now called nominee. Nominee is a word they will respect. Straw man is not. Okay? Trial attorneys seek to locate and attach a judgment debtor's assets and may need to determine whether such assets are being held by the debtor's nominees, alter egos, or successors. Okay? A nominee is one who holds bare legal title to property for the benefit of another. Okay? So a nominee trust, this is a type of trust that is often used in realty transactions, okay? So this is almost, unless it's an actual nominee trust that it's drawn up with like a trust document, okay? You can do it that way. Or it can just be a transactional thing where, like we said, all these transactions create a constructive trust, right? Meaning a temporary trust, okay? So how the nominee differs from how a nominee trust or constructive trust differs from a regular trust is that there's no true release of control, right? There's only release of title, but there's no release of control, right? So when it says bare trust, let me blow this up. I'm sorry. I said I was going to blow it up. Can y'all see that? Trial attorney seeking to locate and attach a judgment debtor's assets may need to determine, I don't want to blow it up so big, I gotta scroll, that's not helpful. determine whether such assets are being held by the debtor's nominees, alter egos, or successors. So when they say a nominee is one who holds bare legal title, so there's regular trust and there's a bare trust, right? You can Google this. So bare trust means the trustee doesn't have the same broad discretionary powers, okay? When you create a regular trust, the trustee, the property now belongs to the trustee, essentially. And though they do have obligations to the beneficiary and the grantor, and of course have to follow the trust document, they do have some amount of discretionary power in which they're allowed to kind of lean into their own judgment for as long as they can claim or show that that judgment was to the benefit of the beneficiary. Okay, the goal is to balance the desires of the beneficiary and the grantor. Okay, so with a bare trust, however, so when it says a nominee is one who holds bare legal title, there is no discretion. Okay, a nominee or a nominee trustee, which is the same thing, middleman, right? He is to do exactly as directed by the beneficial owner. He does not have any personal discretionary power. Okay, so that's what the difference is. Right here we see the nominee theory. Let's see what I'm reading. The nominee theory involves the determination of true, beneficial, or equitable ownership of the property. Okay. Focusing on the relationship between the taxpayer and the property, the nominee theory attempts to discern whether a taxpayer has engaged in a sort of legal fiction. Isn't that what they call the straw man, a legal fiction, for federal tax purposes by placing title to property in the hands of another, while in actuality retaining all or some of the benefits of being the true owner. Okay? There was something else on here I wanted to show you guys. I don't know where it is right now. So we'll look at that. Then we're gonna go to IRS. Well, we're gonna go to the US code first. Okay, so this is their word for straw man. Oh, not IRS defined. Nominee defined. I want to see what this link says. Oh, there's an actual. Let's see. This is LLL Wix. Okay, but see, I don't know what this means. Like, what is this a title of? This is just there. But it is still, it's still Cornell law. So here's our definition, right? A person, sorry, let me turn it to the side. Cornell law, nominee. A person elected or designated by a convention, caucus, or any elective body to serve an office, appointment, or award. Okay? So in federal contracting, you'll often hear them say this contract has been awarded to. Okay? So you could consider the bond the award. If you nominate someone, they've been awarded. This contract has been awarded to. Okay. For example, the U.S. federal Constitution gives the power to nominate ambassadors, public ministers, and consuls. Right here, y'all. And Supreme Court justices, with approval from the Senate, making those persons nominees. All right. Trying to blow this up. Make sure you guys can see it. Might have to figure something else out for the next video if this is not working the way I think it is. Alright, now we're going to go here. We're going to look at nominee returns. Okay, nominee reporting. So this is Title 26, Section 6034A. Big A, right? Or B. So we're B, nominee reporting. Okay, so Title 26 USC Part 6034B, right? Nominee reporting. Any person who holds an interest in an estate or trust as a nominee for another person. Okay? So that's just giving a little bit more validity to what this is. Then they're going to describe, how to file these returns. Blase, blase. That's not what I want to focus on right now. I just want to show you guys what this means and verify, of course, what we're talking about. Nominee returns, IRS. There is a page directly from IRS. Our responsible parties and nominees. That's not the page I'm looking for. IRS nominee reporting. IRS. Right, okay. This is what I was looking for. Okay. Middleman. Think about what we learned, y'all. This is a straw man, a corporate fiction that's been put in the middle to accomplish something that is otherwise not legal, right? A third party. Some of y'all in your documentation with these courts, you'll hear people send off conditional acceptances with the terminology no third parties. Meaning, let me talk to my accuser. Get this attorney, this third party out of the way who's trying to come in and get in between just so he can make money, and this has nothing to do with him. Let me talk to the accuser. This is a problem between me and my fellow citizen. This ain't got nothing to do with the district attorney. He's just here to get in the middle to make money. It's not necessary. Okay? So this is from IRS.gov. Y'all see up at the top here. IRS.gov. Okay, how do I? Okay. IRS, y'all see? Okay. Who must file nominee middleman returns? Generally, if you receive a 1099 for amounts that actually belong to another person. Sorry. If you receive a Form 1099 for amounts, right there, that actually belong to another person, you are considered a nominee recipient. You must file a Form 1099 with the IRS, the same type of 1099 form you receive for each of the other owners, showing the amounts allocable to each, right? Okay, so when you think about it like this, a piece of property obviously can have multiple owners. It's just like a car. How many times has this car been sold? Well, first Bob owned it, then Jane owned it, then whoever owned it. Okay, so when it's a court case, okay, first it's my bond, then I nominated the district attorney, now it's the district attorney's bond, okay? So this is where the checkmate is, because what happens is when this bond is tendered to the court as payment for the administrative violation, right? Because the district attorney he's responsible for all the accounts in his district. So when it comes to his attention that a person in his district has committed an administrative offense, he is required, as your attorney, to tender payment to the court. Okay? And that's where the charge is coming in. Now, the real reason you're here is not because there's a bond on the table, but it's because no one's paid tax on it. There's been no tax paid on this bond. Okay? So what's happening is a state tax lien has come against your estate. Because this $5 million bond is on the table, it has not been reported to IRS and no one has paid tax on it. So when you file that 1099 to nominate the public defender and or the district attorney, even the judge, if you want to be ballsy, okay, you're going to put that responsibility on them. So instead of it being your bond, now it's their bond. Now it's a state tax lien against their estate. That's crazy. You can put a state tax lien on a district attorney. Yep. I did it to mine. And then he has to comply and do what I tell him to. Because if not, now he's liable under the revenue code. Okay? So just looking at these things real quick. Back up what I'm saying. Now we're going to go back to... If y'all wanted to read this more, this is on DOJ's website, so just look up nominee theory, DOJ, and that's this document here. Oh, hello, where'd it go? Well, that was one of the ones we were just looking at, if you wanted to look at that more, okay? I'm gonna move on. Where am I going? I need to go to downloads somewhere. Files, download, private nominee agreement. Okay. This is what we're going to send to the court. So, I had to go through some of my templates and made some edits. I switched over some folders a few weeks ago, just trying to reorganize and copy some things so I could give some of my work partners copies of these templates as well. And it ended up creating a lot of typos. This is the biggest thing I hate about this stuff, is all the paperwork. I'm not a fan of paperwork. It drives me up the wall. But anyway, obviously this still needs to be highlighted here because that's fillable information. I don't know of any real state called any state. Okay, but yeah. So this is the nominee agreement. So this is the trust document. If it's a constructive trust, think of it as a temporary trust, right? That bond is being held with the courts pending trial, right? It's an escrow account. That's why it's pending. You have to see what's going to happen. Is he going to win the case? Is he going to lose? Is he going to have to pay, or is he going to not have to pay? So it's got to be in an escrow account so it can be pending. Okay? So always put the registered mail number. Always send registered mail. If you can't, certified, registered is preferable because it creates an international contract. Okay? If they want to pretend they didn't get the mail, you can go complain with the UPU. Okay? Up at the top, name, address. Same thing here, name, address. Public defender name, okay? If for some reason you don't have a public defender, if you've, got some advice to get rid of them, you're not going to get any remedy talking private law in a public courtroom. Most of the time. Especially as we get further along this process and more people start to find out about this. They don't want a revolution. They don't want a complete upheaval on their hands. So the more people find out about this, the more aggressive they're going to become. And we have to adapt to that and learn how to handle things differently. I do not recommend going into a courtroom talking any of that sovereign bullshit, talking any of that nonsense. Okay, now if you want to learn a little bit of public law, we will get into that eventually to learn some amount of it. So if you really have to go through with a case, say they're trying to charge you with something you can't necessarily just bat down, or you don't want on your record, or something like serious that involves some sort of violence that you want to clear your name for the sake of being still being able to function in society and you don't want something on your name, there are going to be times where you're going to have to go through with the case. So there are some aspects of public law that you should know. For example, how to file a motion for discovery is a big one. Okay, you should know probable cause. What is probable cause, what's not probable cause. That's also going to help you in traffic stops. Probable cause. And learning what the police have the right to demand and what they don't have the right to demand. Just like I said, learning to speak legalese instead of this foolish language you've been taught to use. And I'm not hating on anybody because we all started there. I started there too. I'm just saying we got to move past that point. Okay, so like I said, if you already got rid of the public defender, okay, both the public defender and the district attorney are assigned to this case, account, cause, okay? Case and account is the same thing, okay? So they've both been assigned to this case, okay? So if you can't nominate your public defender, you can nominate the district attorney. You can nominate the judge. You can nominate the court clerk. Anybody who has a fiduciary capacity here, okay? So the district attorney is the attorney over all the accounts in the district anyway, and you live in the district. So even if he wasn't the specific person handling this case, you could still nominate him. You can nominate the district attorney to pay a traffic ticket. Say you got a traffic ticket. You want to write that off. Nominate the district attorney if you don't know the cop's name. Say he wrote it real sloppy and you can't make it out what it is. So I did that once. Nominate the district attorney. Why? Because she works for me. She works for my district. She's the attorney. She's the accountant. She always has the obligation. DA in my county is a woman right now. That's why I keep saying she. Okay? So the only thing is, if you nominate the judge or the district attorney, you cannot send this letter to them. Okay? You're going to have to let them make them aware of their nomination using another document that we're going to go over here in a second called a letter of rogatory. Okay, you cannot communicate directly with the judge or the district attorney during a court proceeding. That's called ex parte communication. Okay, we've done that before. We've been shot down. Like I said, they don't respect this public-private thing. Okay, they really don't. Like, you got to play by the rules. So you can nominate the public defender. Like I said, you can nominate the judge. You just can't tell him in a letter. You have to file a notice called a letter of rogatory into the court file, into the court case, and he can be notified that way. But you cannot send him a letter in his personal capacity the same way you can the public defender. That's ex parte, right? Public defender name here, office of the public defender. This is all very easy stuff, right, guys? R.E. John Henry Doe, of course, that's going to be replaced with your name, account number, case number, SSN. Always use the case number if you have access to it. If you do not have access to it, in lieu of using the case number, you can use the Social Security, but the case number is preferable, highly preferable. Okay. Dear District Attorney name here. I'll see that needs to be public defender. See, I still got more typos I got to correct. And that's all right. I'm gonna I'm recording this now. Then I've got a little space that I've rented out in the library for the next hour, so I'm going to continue recording. And then I've got another hour from 5 to 6 before they close, and I'll go through, make some of these last-minute edits. I have promised this template to a few different people tonight, so I'm going to try to keep that promise. Just a few things. I think that's probably one of the only ones. I did edit for about an hour earlier. Anyway, I'm getting off topic. Okay, so that would be public defender. Public defender. You cannot write the district attorney in his personal capacity. Okay. A 1099 eligible debt instrument secured by the estate of John Henry Doe, hereinafter defendant, was tendered to the courts by the district attorney here on the day, placing certain personal property on deposit at name of court via account number, case number. This account has been assigned to the public defender name here of the public defender office name. In accordance with the Internal Revenue Service reporting requirements, the tax liability has been assessed, and you have been determined to be the recipient. Okay. So, I think I said this in the last video, but I'm just going to reiterate in case I didn't, because I don't remember in the moment. If the charge is administrative, you are not required to pay. Involuntary servitude is a crime. This entire system is voluntary. They cannot force you to participate in it. Now, they don't want you to know that. Okay? Because I believe I said this earlier too, but if I didn't. Okay. The treaty that we came to with Britain, the agreement that we came to, okay, was that we were going to create this system to repay the debt that we owed to Britain. And that was the requirement for them granting us sovereignty and respecting our sovereignty. Okay? So, they kind of can't, if we stop running this system, we're going to have problems with Britain. Because we agreed to run this system in order to repay our so-called debt to them that was probably paid off 1,000,000 times by now. Okay? But at the end of the day, I mean, when we came over, when Columbus and them first came over here, okay, they came with Britain's money on Britain's boat. And this is the United States is a successor country to the Kingdom of Great Britain. And Great Britain is never going to forget that. Ever. Uncle Sam, okay, and Britain is his daddy. And as far as Britain is concerned, I ain't never going to stop being your daddy, and you ain't never going to stop owing me. Period. Okay? And that's why they act like that when people find out. Even if you're doing it right, fair warning, they're still going to be pissed. They're going to be pissed. Because they got to know, oh shit, another motherfucker done woke up. Too many people find out about this, it's going to make them nervous, okay? So this is why I say we got to learn how to do this right, because they're going to be very, very, very angry. Dealing with these people can be very, very intimidating. And if you do not execute everything correctly, you can get yourself into a lot of trouble. Okay? So you want to make sure you learn how to do this correctly. So, like I said, if the charge is administrative, meaning there's no real injured party, you do not have to pay. You are not required to. Involuntary servitude is a crime. These court bonds are performance contracts. You are being obligated to perform. The judge has summoned you, and you must perform by showing up to the court on Friday at 9 a.m. Okay? But like I said, what is performance? Performance is service. Service is servitude. Okay? Servitude, involuntary servitude under the both state and federal constitutions can only be used as punishment for a crime. Okay? If there is no injured party, there is no crime. There's an administrative charge, but not a judicial one. A judicial charge means it's a crime, means there's an injured party. Okay? So they cannot force you to perform unless it's a judicial charge. So you did not have to pay, okay? But you're going to give it to them anyway because you ain't got no choice. They done took it. They done charged you. Okay? But you're going to say, hey, this is not for free. This is not pledge. This is payment. Pledge is security. Pledge is, it's like when you buy a car, right? So you promise to pay $40,000 and you also pledge the car to them as surety. So this car is going to remain in your name as collateral or surety. Collateral or surety. Understand the interchangeableness of those terms. Collateral or surety. Okay? This car is going to stay in your name, legal title, in your possession as surety for this debt until I pay this debt off, so you can be assured that you're either going to get your money or you're going to be able to repossess that car. Right? So the tax liability has been assessed and you have been determined to be the recipient. Why? Because I did not have to give this to you, so I'm not going to give it to you. I'm going to report it on a 1099, and then it becomes taxable income. This is commerce, folks. I'm not pledging anything. Pledge is voluntary. Pledge is tribute. Pledge is yes, king, yes, master, yes, this, yes, that. If I haven't done anything, you ain't got an injured party, I'm not pledging anything. I don't have to. This is commerce. You want this bond? Pay the taxes on it then, because I'm not doing it. So in accordance with the Internal Revenue Service reporting requirements, the tax liability has been assessed to you. You have been determined to be the recipient. Please negotiate, settle, and close the account in accordance with the following terms. Okay? So we got the power of authority. I, John Henry Doe, this is just saying this is who I am. This is why I have the authority to issue this agreement in the first place. Right? Terms of performance. So like I said, if it's not judicial, they cannot force you to perform. Now, as I said also, the treaty, okay, says that there shall be peace between the creditors.
Is that you? Oh, you just look at someone else, sorry.
It's okay.
My bad.
Peace between the creditors, right? Debtors are not guaranteed peace. So, the way I was taught, I listened to Creditors in Commerce, Brandon Pope. Be an honorable creditor. Now, if it's something just small, stupid, they're just really big tripping, like this didn't need to happen at all, I really didn't do anything, then maybe you would just demand they could shut out the whole thing. But if you actually did something, you were selling drugs and you had 10 keys of coke in the back seat, give them some credit. Give them some credit. I mean, listen, you can do what you want. Debtors are not owed peace. That's all I'm going to say. The peace is guaranteed between the creditors. That's what the treaty says. Do what you want. Okay? So along with this documentation, if you're going to credit them and just negotiate the charge down, which is what I would recommend doing if you actually did something that was irresponsible or highly socially unacceptable under this current social hierarchy that we live in now, like having 10 keys of coke in the backseat. Though not a crime, it's highly socially unacceptable. Okay? Give them some credit. So then the tax form you would file with that is an OID. If you want to completely abandon the bond altogether, close this case. I'm not paying nothing. I'm not performing nothing. I'm not doing anything. This was just some random on the side of the road profiling nonsense. I'm not participating in any of this. You would file the 1099A, abandonment of the bond. 1099 OID is, yeah, I issued this. Yes, I'm participating. Yes, I agree to be the surety. Yes, I agree to perform. Okay. Now you're going to force your attorney to negotiate to a much smaller, much more reasonable, something you can deal with type of deal instead of just railroading you. Okay? But the OID is, I issued this bond for free, here was my discount. Whereas the A is, I give it up. I don't want anything to do with this. I refuse to perform. Okay? So terms of performance. So now that we've established that this is administrative and I'm actually not obligated to perform, here's what I'm willing to do. And here's what I'm not willing to do. So first of all, before you guys get all excited thinking you're just finna railroad me and make a bunch of money, there's no injured party. So let's, up front, I don't have to be here. Okay? Now, because I know that you got the guns and the power, it's in my best interest to cooperate to some extent. So here's a list of what I'm willing to do and what I'm not willing to do. Under no circumstances whatsoever shall the defendant be detained for more than 180 days on any charge in which there is no valid injured party. 180 days, what is that, 6 months? Okay, now of course you can edit these to your liking. This is what I feel personally within my heart and soul that is fair. Okay? Or for more than 45 days for statutory charges valued at less than $30,000. So even if the charge is statutory, half of 6 months in jail is still a long time. So if it was worth less than $30,000, what, I had an ounce of weed on me? Let me out of here. Now, if I had 10 keys of coke in the back seat, I'll do 6 months. That's fair, if you ask me. But if I had an ounce of weed on me and you just are some Bible thumper who doesn't like marijuana, well, marijuana's legal in my state, sir. You ain't got to like it. It's legal here. On statutory level, and what am I talking about? Legal, right? Even on statutory level, weed is legal here. All right, so we're not doing that. No. I'm not doing more than 45 days. And honestly, I think I might make that one smaller. It's 45 days. That's a lot of time for a weed trial. I wouldn't do 45 days behind no weed. No, ma'am, I wouldn't. All right, no claim. Number 2, no claim on be unlawfully converted from civil into criminal. Okay, so that's what these people are doing. Like I said, let me show you guys something. The state code, which you need to understand, does a house have power? Or do the people who live in the house have power? Do guns kill people or do people kill people? I'm not saying that for you to agree with it. I'm just, this is not a NRA promotion. Oh, come on. Okay. If I break into a house, can the house call the cops on me, or do the people who live in the house have to call the cops? The point I'm trying to make, if I does a car drive itself, or does a person jump in and drive the car? The point I'm trying to make is that the state has no power. The people of the state have the power. Okay? Just see a California government code. Yeah, see that? I try to show you what I'm talking about. I'm not just pulling stuff out of my ass. Okay? The sovereignty of the state resides in the people thereof. And all writs and processes shall issue in their name. Their name. Okay? So that means no inter party, no crime. The charges are supposed to issue in the name of a natural person. The sovereign power of the state is vested in the people of the state. The people, okay? So when they say, oh, well, you had 10 pounds of marijuana in the back of the car and that's a crime. Really, it's a crime? Where's the sworn complaint from the injured party? Where's the writ issued by the sovereign? Where is it? You don't have it. Exactly. So what they're doing is they're converting civil charges into criminal charges. And this is why they call this kangaroo court, because what's happening is not what you think is happening. You're being sued on a civil level for a war debt that's owed to the Kingdom of Great Britain under the treaty. Bet you didn't know that, did you? But you think you're here because you had 10 pounds of weed in the trunk of the car. They don't care about that. These people decided 300 years ago, not quite that long, that they were going to steal all your money. It's not really about what you did. It's about the fact that they want your money. Okay? So they're converting civil charges into criminal. So no claim may be unlawfully converted from civil to criminal. A sworn complaint from a citizen of one of the several states in a sworn Article 3 tribunal must occur, so a judicial tribunal, not an administrative tribunal, must accompany all criminal charges. This letter, number 3, this letter is sent in the nature of Miranda. Alright, I'm sure all y'all know what a Miranda warning is. So I'm just letting them know, hey, I know the game jig's up. You better act right from here on out. Because if you don't, there's going to be consequences. All civil claims will be subrogated without exception. Meaning, I'm going to always nominate my attorney. Because as soon as I put him in hot water, now all his little fiduciary obligation to the bar, well, how much does it mean to you, bro? You want to make the bar money and go to jail yourself? Do you want to perform that performance contract? State said I was doing 5 years in the federal penitentiary. Okay, well, do you want to keep your fiduciary obligation to the bar so bad that you're going to do 5 years in the state penitentiary because I just assigned you the bond? That's your contract now, sir. John Henry Doe is not doing a goddamn thing. So unless you're going to do 5 years in the pen, I suggest you call them little bar people and work something out. I don't know what to tell you. You're kind of stuck between a rock and a hard place, aren't you? Real quick before I forget, if you guys want to see that, all they tell you, oh, the attorneys have a higher American Bar Association duty to the court than they do to you. Y'all want to see the proof? You want to see their constitution? They have a constitution? Yeah, the American Bar Association has a constitution. So does every nonprofit you've ever heard of, most of them. So do all these sororities. So does the Freemason Society. Y'all know what the word constitutor means? What's a constitution? It's a specific type of contract, just like a trust instrument, or a will is a specific type of contract. Okay, a constitution, a constitutor is one who stands as surety for another. Okay, so when Britain decided, hey, well, you owe us money, the United States came in and decided, we will stand as surety for the people of the states. Since we can't agree to get them to pay for it, we'll pay for it, and we just gonna have to come up with a system in which we can convince them to pay. Okay, so either they pay for it or you pay for it, but one of y'all is going to be in hot water, and this is why they don't like it when we find out about their game. Because if we're not paying, then they're going to have to pay, and if nobody pays, the king is coming with his military because we violated the treaty. This is why I say wars are never really over, they're just on pause. If anybody decides to violate the terms of the treaty, that war can come back with a quickness. This is the Constitution, y'all. All you got to do is Google it. ABA, American Bar Association, Constitution. Okay? I'm trying to find the part where it says that they have the obligation. Oh, this is interesting. It says nominating petitions may be in parts. So I wonder if you petition for this. So you're basically asking the judge to give you permission to nominate. For those of us on the higher level, that's an interesting tidbit that needs to be dived into right there. For those of us still on the lower level, you probably have no idea what the hell I just said, and I don't blame you. I'm not quite sure I can wrap my mind around that yet. I'm playing. Okay, other meetings, resolutions, presentation, House of Delegates. Okay, what did it say? It says something about the United States up here. Right. The purpose of the association are to uphold and defend the Constitution of the United States. Well, that's obvious. And maintain representative government to advance the science of jurisprudence, to promote throughout the nation administration of justice and uniformity of legislation. Okay, I thought I saw something about a custodial relationship the last time I read this, but I found it pretty quickly and I moved on to something else. I'm not going to take up all day looking at this, but if you guys want to look at that, if someone finds where it says that, please post it in the comment section. That would be cool. I'll find it eventually, but I'm not going to waste too much time on that. Alright, so let's get back to what we were doing. But yes, they have their own constitution, okay? So that's what a constitutor is, right? It's one who stands as surety for another. It's essentially like, they're like insurance companies, but they're just not called that. An insurance company does the same thing. You go pay insurance, you pay a little premium, a little $75 a month, and the insurance man holds on to that, $35,000 policy, which is the minimum for liability, at least in California it is, $35,000. And he agrees to stand as the surety in case you get into an accident, and if he has to pay up to $35,000, he's going to pay it. It's the same thing, okay? So the Freemason Society got one. Now all these people are constituting, and they all have their own constitutions. Now some of them are registered corporations, so that their constitution is in accordance with the United States Constitution. Some of them are unregistered corporations, so that their constitution stands alone. And they're operating from a completely different jurisdiction. I mean, this is what's going on right underneath your noses, folks. All right? So anyway, number 3, sent in the nature of Miranda, all right? We're not playing around. All civil claims will be subjugated or subrogated without exception. So I'm not ever going to play this debtor game with you. I'm always going to be standing in the position of the sovereign, just to let you know. The estate of John Henry Doe values integrity, responsibility, and diplomacy. All properly applied and fairly assessed civil claims shall be tendered without contest. Such contracts shall be negotiated first to the benefit of John Henry Doe and then to the benefit of the court. So there what we're saying is, hey, if I actually did something irresponsible, okay, we'll play this game. I'll credit you as an honorable creditor. Remember that only creditors are guaranteed peace. Okay? But you're not going to railroad me. You're not going to give me way more time than what I deserve. If there's no injured party, I'm not serving any time. We can do this probation thing, but it's not going to be unreasonable. You're not going to, put so much in my head that I can't focus, that I can't work, that it affects my bank account or my personal life. We're not doing any of that. Stop railroading the people, because most people don't really want to have no responsibility and they have to answer to no one. They just want the court and the justice system to stop playing so unfairly. Okay, so when you see these famous people get into trouble and they have all these high-profile attorneys, and you think that it's the money that's making these people take these people more seriously, it has nothing to do with the money, folks. Because they took me just as seriously, and I didn't have a dime to my name. Not a dime. It's the knowledge. The knowledge is the power. On the next video, I found out some cool stuff about lien financing I'm going to share with you guys. Okay? The knowledge is the power. Money is not real. It's just paper. The knowledge of how the monetary system works, well, that's how you get rich, folks. It's the knowledge that's the power. not the money. Because you would have thought I had a Johnny Cochran-ass attorney too. And he was a public defender. The ones y'all swear don't know anything. Those low-grade public school lawyers who just... oh, they're just dumb. Granted, some of them are. Some of them are. I saw a couple public defenders in there. I was like, man, are you sure you went to college? Because, like, where? Like, junior college? Like, would you go for 6 months and drop out? And you look like you're not even smart enough to work at goddamn social services, yet alone be a whole attorney out here, but okay. My attorney was a real smart dude. He used to be a private attorney. He practiced in the Bay Area for a lot of years. But he was still an attorney, okay? At the end of the day, these people make money from locking you up, even when there's no reason to lock you up at all. So understand that the attorney, no matter how cool he is never your friend. All right, number 5, all such performance shall be carried out by John Henry Doe in either his or her public or quasi-public capacity, for as long as said performance is mandated in accordance with any activities required for his survival without unreasonable administrative interference. Okay, so my brother is a knucklehead. He grew up in and out of juvie, first half of his adult life, in and out of jail, in and out of prison, okay? So I have some personal experience with this, okay? They've paroled him to towns where he had nowhere to sleep. He doesn't know anybody there. Knowing damn well, my mom lives in this county. No, but that's where you got in trouble at, and I get that, but I mean, okay, so if he gets in trouble again, then he goes back to jail. I mean, I think that after you serve your time, your rights should be restored. Like, it's unreasonable to ask a person to parole to a county where they know nobody and they have nowhere to lay their head. Whether they're supposed to sleep outside, that's crazy. But this is the stupid type of stuff they do all the time. Why? Because then when you miss the court date, guess what? They get to issue a warrant and go pick you up again and make some more money. Right? So we're not going to allow them to do anything, any unreasonable administrative interference. This has got to make sense for my life. So to be determined by the court that no constitutional violation or civil offense has been committed and that no higher claim to the account in reference can be located, please settle and close the account to the benefit of the defendant. Okay? Defendant hereby appoints. Okay, so then we have the appointment. So this is just fancy language that has to be included in the document. Appointing them, and we're going to list their duties, right? So authorities, here's the things we're giving them the authority to do. You have the authority. We'll see, that says trustee too. That needs to say defendant. Man, you would think I didn't edit this thing at all. The nominee is hereby authorized to delegate or subdelegate any of the authorities. So if you don't want to do it, which a lot of times they will have someone else do it because they don't want to violate their oath to the bar. Okay, it doesn't matter. That's cool. You can have someone else do it, but somebody's gonna do it because it ain't gonna be me. Okay. Or a lot of times you'll send in, like, and this is what I was saying earlier. Well, I think this was one of the videos I deleted. Is that the guy I got this document from? Now I did a lot of editing to this document, and I still, like I said, if you want me to do this process for you, I will charge. But I give this template away for free because I got it for free. I believe in being honorable. This template, the version that he made, is on Scribd right now for free. So I'm not going to charge for it when I got it for free. Yeah, no, I put some extra effort into it. But listen, I'm trying to create equity out here. I'm not just in it for the money. And at the end of the day, the truth of the game is, if you know lien financing and you know truly the money game, you don't need these people's money. So anybody out here trying to charge you, I mean, I know people charging $10,000 for trust, which is cool, because trust can become very complicated and high-profile clients are very much willing. Attorneys charge 10 grand, 20 grand for trust all the time, but here's the thing, you're not an attorney. It's crazy for you. You're not an attorney. It's crazy for you to be charging 10 grand for a trust. Now, I had someone who gave me some information on how the Rockefellers write their trust. Gave me a template from a Rockefeller trust. That's crazy, right? I got that for free. So do you think when I get all that together and I've read through that and I've looked at what it all is, because first of all, I'm not going to give that to anybody, not to set up. Now, if you just want to look at it and do it and go into yourself, okay, cool. But if someone hits me up, hey, I want one of them Rockefeller trusts, I'm not doing that until I've read it. I need to know what's in this trust that I'm giving to you, because I need to know how it operates so I can explain it to you, right? That's just how I work. But You think I'm gonna be charging 10 grand for that when I got that for free? That's not honorable, man, and I don't believe in that. But what you'll notice is, some people get to a level in this game and they start thinking just like the people who we're trying to fight against. Like, oh, I'm better than, I'm above. That's why y'all running into a lot of these people who don't want to break this down into plain English for you. Because listen, if you got the type of brain where you can absorb this information and you can self-teach yourself this, you've got the ability, the cognitive ability to break this down into regular ass plain English and explain it to any Jim, Joe, Bob on the street. You just don't want to. Because as I've said before, if everybody knows the game, then the game doesn't work anymore. Capitalism requires some group of people to be in the dark. Otherwise, it doesn't work. Because if everybody could do the credit game, the banking stuff, the lien fine, nobody would be working. And then the whole thing would collapse. And when you get to a certain level, you figure that out. And most people at that point, that's when they shut up. That's when they stop telling you things. That's when they stop giving you clues. And at that point, it's well, if you're not smart enough to figure it out, you deserve to be a slave. I don't believe that people who are not brainiacs deserve to be enslaved by their own government. I'm not that person. So, I'm sorry, y'all. I like to go on tangents. I'm passionate. Anyway, so we're going to give them the power to delegate, subdelegate. Like I said, they can assign it to, if he wanted to assign it to a lower level public defender or the alternate defender. In my county, they have a public defender and they have an alternate defender, 2 different offices, right? They can do that, but it has to get done. The nominee is hereby number 2, authorized to use any funds or assets held in escrow and released pursuant to the debt instrument, aka the case, the summons, okay? Those are the debt instruments. To set off the account, basically. Number 3, authorized to ledger the debt instruments and the attached payment coupons to set off the account. Okay. The nominee is authorized to use the account and routing numbers. Number 7, the nominee is authorized to release any and all funds or assets remaining after the settlement and closure of the account to the defendant. Number 8, the nominee is hereby authorized to ledger IRS Form 1099 OID. Now, like I said earlier about OID versus A. OID is that you're going to participate in the contract, so you're going to agree to be the surety, right? Or at least until it's transferred to the next person, right? But that's for more if you want to negotiate. Whereas A is I want to abandon this contract altogether. Okay, now like I said, how you decide to live is completely up to you. I'm not your mommy. I'm not here to tell you what to do. I'm just saying that the treaty says that peace is only guaranteed between creditors. That's all I'm saying. Okay. Surety. I, the undersigned, being duly sworn, dispose and say that the defendant is a surety to this contract. Defendant does hereby pledge the following assets. So we're going to pledge the account statement. So that would be like any paperwork you have from the court with that case number on it would be the account statement. Okay. The only reason why there's not numbers at the bottom is because they don't want you to know that this is a civil charge and that there's money involved. Okay. So anything you've got, the summons, whatever, if it's a traffic ticket, it would be the ticket. Okay, if it's, like I say, a judgment, a civil judgment, whatever notice they sent you that was saying, hey, the court has declared that you're going to pay this much money, okay, then that would be the account statement, okay? Endorsed by the defendant, so you're going to flip it over and endorse it. Look up UCC endorsements, okay? I would do restrictive endorsement, okay? Pay to the order of the nominee, restrictive endorsement, okay? 1099 OID payment coupon authorized by the defendant. Again, keep in mind the difference between the OID and the A. It's not my job to tell you how to live. Number 3, assets and or funds held in escrow for the defendant and the account held by the financial institution, which in a court case, the bank or the court is acting as the bank or the financial institution, and asset account number, which would be the case number. Then number 3, we're gonna indemnify the public defender in regard to his duties. Okay. Duties of the nominee, that's standard in any contract. People don't want to ever be responsible if shit goes wrong. Indemnity clauses are standard in most contracts. Duties of the nominee, so here's your duties. You're going to perform this within 10 days. So under administrative law, 10 days, right? 10 days is how long you get to respond to an offer, okay? Pursuant to the debt instrument in this contract, the nominee is hereby authorized to set off the debt and to use the property held in escrow exclusively for the settlement, set off, and discharge of the debt. Okay. Number 3. Number 2 pretty much says the same thing. Number 3 is hereby directed to ledger the instruments for the set-off, settled. Okay, so it's very specific, but basically, hey, close the account. Number 5, nominee is hereby directed to issue a statement of account reflecting the payment. Okay. And the nominee is hereby directed to release any and all funds, assets remaining after the closure of the account to the defendant. Okay. Acceptance and refusal. So here's what's going to happen if you do not accept this contract. Okay. You have 10 days after the postmark. So after, I send it registered mail, I get the little thing back. Okay. They received it. Okay. You've received it 10 days from now. You got 10 days. Okay. Any refusal of this contract must be accompanied by a sworn affidavit signed under penalty of perjury and stating that the nominee does not have the capacity, authority, obligation, and duty to set off the account, blah, 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 perform the duties, ledger the information. Okay. Here's the thing. He's been assigned to the case. He has the obligation to perform this. He can't say no. He can't. He's been assigned to the case. The district attorney has also been assigned to the case, okay? Even like I said, if you say it's a speeding ticket, the district attorney that's not a case. The district attorney's name is not anywhere, right? But still, he's over the office. He's the head administrator for the district, right? He's the head financial officer, next to maybe like a commissioner or something from the IRS, right? So, any type of debt that you got that's secured by your estate that's being held in probate with the United States, with the state of California, the state of Texas, the state of whatever, okay, the district attorney always has the obligation to discharge that for you. Why? Because he's the attorney, he's the accountant for that district, and you are a resident of that district. So he always has the obligation, as does the public defender if he's assigned to the case. Now, sometimes what they'll do, especially because when I got this information, how it was written was he recommended sending in the forms and asking them, directing them to do the discharge themselves. Okay, I don't recommend that. You have every right to administer your account for yourself. That's what I recommend. These people know what they're doing. They know they're lying. They know they're playing this game. Okay, so when you're dealing with me, by the time we get into court Monday morning, that tax paperwork is already filed, and there's already an estate tax lien. There's already a tax lien on your estate, sir. This is not optional. You work for me, and you will do as I have directed you to. I'm not going to wait for you to do it. But that's how, I was taught with this specific person. That was the way he wrote this agreement. Okay. I had said that for a reason. All right. So that's how he would be able to refuse this, right? So if I've already nominated you and put that tax form in, and you've already been assigned to this case for at least 10 days, you can't refuse it. See how that works? Okay. So this is where you're hanging them. Because like I said, he's been assigned to the case. It's been more than 10 days. He's already obligated. And like I said, the district attorney is always obligated. Okay? So this is where it says, send me a sworn affidavit saying that you don't have the duty to do all of these things. And they're not going to send that because they do have the duty. All right. I've got some rented time in the little booth now. I'm 11 minutes late, so I'm going to take a break from this video. We're going to pick up with liability of the nominee. And we'll be right back, you guys.